morning, we will call the Senate Judiciary Committee to order, and our first order of business is to open the hearing on House Bill 2109, increasing the county population threshold for a county to be required to have a lawyer representative, and some other matters as well in the bill. So with that, we'll have a bill brief from our reviser, Mr. Thompson.
Thank you, Madam Chair. Good morning, committee. Jason Thompson with the Reviser of Statutes Office. House Bill 2109 changes the requirements for the Board of Indigent Defense Services appointments. Current law there in the bill is KSA 22-4519. That, of course, establishes the board and provides that it has 9 members appointed by the governor, subject to confirmation by the Senate. And we've done a couple of those in this committee, as you may recall. The current requirement in that section is that each county with a population over 100,000 shall have 1 member of the board, and the board is made up of 5 lawyers and 4 non-lawyers. The bill amends the statute to provide that 1 member of the board will be appointed from each county that has a population over 115,000 rather than 100,000. And the bill also amends the statute to provide that 6 members will be lawyers and 3 members will be non-lawyers. And I think you'll hear from the proponent conferee that there are some population issues, and we now have more counties with a population over 100,000 than the statute would allow to be appointed. So there's a statutory conflict going on with the population number and who can be appointed and from where. So I'll stand for questions at this time.
Thank you. Committee, any questions for the reviser? Seeing none, I will note for the committee that House Bill 2109 passed out of the House with a vote of 87 in favor and 36 against. So with that, we will invite our first proponent conferee, Heather Cessna from the Kansas State Board of Indigent Defense Service, to the podium. Please introduce yourself and welcome to committee.
Thank you, Chairperson Warren and members of the committee. My name is Heather Cessna, and I am the Executive Director of the State Board of Indigent Defense Services. And I'm here in support of 2109 and to answer any questions that you might have. As the reviser pointed out, this is to fix a conflict that we have in the statute. We currently only have 8 board members that are appointed because we are unable to appoint our last board member due to the conflict in the statute. As you will notice when you review the actual statutory wording, our board appointment statute is pretty convoluted in how it comes to the makeup of our board. And that's intentional in order to try to cover as many areas as possible to have a good mix between public and attorney members, to have a good mix of private potential ability of private counsel versus other types of counsel, as well as to have a good mix between rural and populated areas. And so in creating this statutory fix, we tried to stay within the spirit of that intent. And this wouldn't change the actual number of our board member. It simply errs on the side of allowing an additional population member to our board that's an attorney member, which allows us to keep a decent number of our public members, which provide a lot of important feedback to us and a lot of good assistance to us as we're working on issues. But one of the things that sort of led us to come up with this particular fix is because 85% of all adult felony cases in the state of Kansas require appointed counsel, and we provide all of those, either through the public defense system or through our appointed counsel. And so essentially we're running the largest criminal defense law firm in the state of Kansas. So it makes sense because of the unique requirements and the unique considerations that we often have to make on a daily basis or weekly basis on how we're administering that system, that we do have potentially an additional attorney member beyond what has been there. The change to the population standard allows us to have some additional time to go back and work hopefully with a full board once we get our last board member appointed to conduct what we've already begun to do, which is a full review of all of our statutes and regs, They are definitely in need of some updating. And I think the additional population increase here will allow us to have the time to be able to do a comprehensive review of all of our board statutes before this same problem becomes an issue again. I think the population projections indicated it was going to buy us between 9 to 10 years before this would potentially be an issue again under the new wording of the statute. With that, I'm happy to answer any questions that the committee members might have.
Sure, thank you. And I will ask then for, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then committee, any questions for our proponent conferee? Yes, Senator Gossage.
Thank you, Madam Chair. Thank you, Heather, for being here. As we discussed, as you know, I've been a member on this board appointed by the governor. And can you explain why it is that you haven't been able to find another member that meets in the current criteria?
Go ahead and introduce yourself, please, and then you can reply. Thank you.
This is Heather Sessner responding. It's because we had at the time that the original wording, it's not that we couldn't get somebody to qualify under the statute, it's that we cannot appoint an actual member because the statute language conflicts. So we have a certain number of counties within Kansas that have qualified under one subsection of the statute to have an attorney member because they have a county over 100,000 people, but we have a limit on the number of attorney members on the board that prevents us from being able to do that. At the same time, we have a vacancy on one of our public members, but on one of our current public members that is not appointed right now. But if we appoint that public member, then we're denying the additional county that has qualified for council. So it's not that we couldn't find somebody to qualify, it's that the actual statutory language is preventing us from being able to appoint that last member.
And just to follow up, so you have two different issues. We have the issue that if you were to raise this to 115,000, there would be fewer counties that would qualify. So that would help, is that right?
The same number of counties would currently qualify. Raising it to that number would put any additional counties from qualifying off a little bit longer to be able to give us the chance to conduct a review.
Okay, and then explain to me, because again, what was discussed in the meetings when I was there was more like how much money should we ask for, the budget, et cetera. And of course, if you've already got this kind of imbalance of 5 attorneys to 4, you're going to have, of course, more attorneys going, yes, they should get more money. And then you may have more people in the 4 that are saying, we need to look at the total budget as a whole. And can you explain to me why you think this is a better idea to have 6 attorneys?
I don't think that we can assume that just because somebody's an attorney member that they're necessarily going to support more money for the board when we're considering our budget issues. I mean, I think that's going to really depend on the actual makeup of the board, which is determined by the governor and then with Senate confirmation who those members are. I think the considerations that we have done in the past were relatively superficial as far as basic budget considerations, but our system right now is in serious enough difficulties and with enough ethical problems with our caseloads and things like that, that we really do have to get a lot more down into the weeds than probably our previous director would take us down. And so I think going forward, it's going to be much more of an issue where we're going to have to take into consideration some of these particularly attorney-specific related questions that I think having that additional experience would help. And like I said, I think we still are able to maintain a significant number of our public members because their input is very important and it's very helpful to have.
Thank you.
Senator Baumgardner.
Thank you, Madam Chair, and thank you for being here today. It's interesting. It seems like a fairly straightforward bill, and no neutral and no opponent, and only one proponent, and that was true in the House as well. Could you share with us why nearly a third, just under a third of the House voted against?
I don't have any specific, sorry, this is Heather Sussman again, for anybody who's listening. I don't have any specific details about why those particular members, there weren't many people who actually got up and spoke about why they voted particularly against the bill in that large of number. I do know that in talking to Representative Stephen Owen, who did stand up at the House and speak in favor of the bill as a very conservative member of the House. I believe that there was some indication that it had gotten a negative rating from a conservative organization that indicated that it was expanding government or something along those lines. And I know in talking to him afterwards that he had indicated part of the reason why he stood up and supported that on the House floor was because he wanted to clarify that it wasn't that we're expanding anything. Our board is still staying the same number. It's just the amount of makeup. It's not going to change the funding of the board or add any additional costs to the state or anything like that. I would certainly encourage you, if you have questions about that, to reach out to the House members, because I think they can probably shed more light on that than I can speculating. But I know I had that conversation with him specifically.
Thank you. Committee, other questions for our proponent? I have a question. Something you said, ethical problems with caseloads. How does that relate to the bill, and what are the ethical problems, I guess?
Again, this is Heather Sussman. The ethical problems that we have with caseloads is within specifically our public defense side, is that we have across the board too high of caseloads for our staffing. And so one of the difficulties that we are trying to address with some of our budget requests this year, and in response to a staffing report that was requested by the Legislative Budget Committee, was attempting to address the additional staffing needs that we have in order to not have too many cases per attorney. Obviously, as an attorney, you have ethical rules that require you to not have too many cases that you cannot handle. And one of the problems that we have in our system is that we don't have the ability to stop the number of cases that come into our system. It's just a question of where they go. And in a lot of counties where our public defenders are that first line of defense, traditionally, we have not done a very good job of controlling those caseloads in a clearly ethical manner, and that has caused a lot of turnover and burnout and other related issues. And so now, as we're attempting to better control those caseloads, that's causing ancillary problems with issues like having too many cases going to our assigned counsel program and not having enough counsel on our assigned counsel list to handle those cases. So it's a complicated, although not necessarily difficult to understand problem that has really informed our budget requests for this year and really informed a lot of the conversations that we're having with our board right now about our staffing issues and things going forward.
Thank you. Does anything in the bill, we've heard a lot in this committee about statutory speedy trial. Does any of this help with the staff needed to get some of those cases to trial sooner?
Again, this is Heather Sussman. This bill itself only deals with the makeup of our board. Certainly having a full board in order to help us deal with some of these issues will be helpful going forward, but there's nothing specific about this that would have a direct impact on that question.
Committee, other questions for the conferee? My last question is, I think the bill talks specifically about one county. Was that Douglas County? Yes, Douglas County. And is that because it's a county that's grown from under 100,000 in population to 115,000, and it's meant to address that particular county?
This is Heather Sussman again. That is the county that had triggered this particular issue, although, as I said, I mean, right now with the language the way it is at 100,000 as opposed to 115,000, we do anticipate that there will be potentially additional counties. If I remember correctly, I think the original thought was it might be Leavenworth and maybe Saline or Riley County. I can't remember which one there. So the raising it to 115,000 would allow Douglas, since they've already qualified, to have their representative, but then give us the time to maybe have a bigger review and a larger attempt to address this issue going forward before any other ones come up.
Thank you. Committee, any questions further for the conferee? Seeing none, then thank you for your testimony. Thank you for appearing today in person. Appreciate that.
Thank you very much.
I see on the agenda we don't have any neutral conferees listed, but are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. We don't have any opponent conferees on the agenda, but are there any opponent conferees in the committee room or on WebEx? Seeing and hearing none, then we will close the hearing on House Bill 2109 and open the hearing on House Bill 2076. We will ask then for a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the reviser of statutes again. House Bill 2076, as amended by House Committee, clarifies that bond agents are required to return certain people released on bond to the court in the county where the complaint subject to the bond was filed. The bill amends KSA 22-2809. That's a statute in our Code of Criminal Procedure relating to sureties. Current law provides that a surety seeking discharge of an appearance bond may arrest the person who is on the appearance bond and deliver the person to a custodial officer of the court in any county in the state in which such person is charged. The bill changes this to require delivery of the person to a custodial officer of the court in the county where the complaint subject to the bond was filed. So rather than any county in the state in which the person was charged, to the county where the complaint subject to the bond was filed. The House Committee on Judiciary added an amendment in subsection B to define custodial officer of the court as the sheriff or the keeper of the jail in the county. So those are the two people that you could return a person to under the bill, the sheriff or the keeper of the jail. And with that, I'll stand for questions.
Thank you, Mr. Thompson. Committee, questions for the reviser? Seeing none, we will invite our first proponent conferee to the podium, Jeff Easter of the Kansas Sheriff's Association. I think Mr. Easter is appearing on WebEx, so please introduce yourself and welcome back to committee.
Thank you very much, and good morning, Chairwoman and all of the members of the committee. My name is Jeff Easter. I am the Sheriff of Sedgwick County and represent the Kansas Sheriff's Association today. And so just very simply with this bill, currently right now, if you have an individual that has a warrant out of Dodge City, Kansas, and they are picked up in Lawrence, Kansas, the bond that had been revoked with that particular bondsman, at times, not all bonds people, because we have some that are very ethical and those type of things, but you have some that just take the individual over to the Lawrence jail or Douglas County jail and book them there, and then it causes Dodge City to have to drive out to or drive up to Lawrence to pick up the inmate to get them back into their custody. We're simply asking that if a bondsman has a bond that's revoked and they pick up that person for that bond revocation, that they deliver them to the county that the warrant was issued or the bond revocation happened. And that's simply the what the bill is asking for. We would ask for your support in this, and I'll stand for any questions.
Thank you, Mr. Easter. We will hear from all the proponent conferees before opening it up for questions. So with that, we will hear from the next proponent conferee, Shane Rolfe, Kansas Bail Agents Association. Please introduce yourself, Mr. Rolfe, and welcome to committee.
Thank you, Madam Chairman. Chairwoman, my name is Shane Rolfe. I am the Executive Vice President of the Kansas Bail Agents Association. We do support passage of this bill. This is essentially the third hearing we've had on this. This came up last year and obviously didn't make it through because of pandemic, and then we've had another hearing in the House side. And a couple of questions have kind of arisen about this from the questions we've had from members about this, and I kind of wanted to address those. Is what the basics of a surrender is and what we're actually talking about with this situation. What we're talking about is not so much, a bond revocation or anything. We're talking about when the surety picks up someone and delivers them back to the custodial officer of the court, essentially returning the defendant to the same condition they were in prior to posting bond. Now, most often, the reason that a surety would do a bond surrender is that the defendant has failed to appear in court as ordered. The person doesn't go to court, the bondsman goes and picks him up. This is what everybody's classic understanding is of what a bondsman does. In this scenario, there's almost always an active bench warrant for the defendant as a result of the failure to appear. And in our mind, and I know this will conflict, even though we're both support the bill, this will conflict a little bit with what Sheriff Easter said. Returning a person to law enforcement custody who has an active warrant for their arrest, wherever that may be, does not really create a real problem. And while we obviously encourage our members to surrender fugitives or deliver surrenders fugitives to the appropriate jail, there might be instances where that's not really practical. Defendants who are particularly combative, instances where there's some external threat, and this external threat idea is something that was brought up to me or particularly addressed by one of our members after the last hearing. It was a situation where some of the defendant's buddies were chasing them down the road as they were trying to take him back to surrender the bond after he'd failed to appear. And they took them to the nearest jail to avoid any further complications of that. Now, they didn't surrender him at that jail, but he was taken into custody on the warrant at that jail. And that situation, we think when there's situations like that, the best solution is to get that person back into custody as soon as possible. It's safer for the defendant, it's safer for the bondsman. And when there's an active warrant for the arrest of the defendant, this doesn't really create a problem. I realize there might be some additional transport issues, but it doesn't create a problem with taking the person into custody. Even with this proposed change to the statute, a bondsman with a problem defendant probably could still go to the nearest jail and say, hey, I've got this guy, I'm not going to surrender him, but he's got an active warrant. Can you take him into custody? And in theory, law enforcement would be obligated to do that if he's got an active warrant in the state of Kansas. Now, I'm not advocating that we would do that on a regular basis, and I think Sheriff Easter acknowledged that we don't do that on a regular basis. And this sort of delivery would not technically be a bond surrender, and the bonding company would have to go through a different mechanism for exoneration, but it would get an absconding defendant back into custody, which I think everybody could agree is the primary goal for everyone concerned when the defendant has failed to appear, is getting them back into custody. Now, there may be some additional costs associated with returning the defendant to the proper county jail. Another state statute does authorize the assessment of those costs against the surety, although that's not done on a regular basis. It can be done. But again, the important part is the fugitive has been returned. And additionally, I mean, this is our own little plug here, given in this era of various attacks upon bail, eliminating bail and all the issues surrounding bail, I think it's important to point out that this instance that we're talking about here, the issue we're trying to address with this bill, the sole reason that the fugitive has been apprehended is because of the actions of the bonding company. If there were no bail bondsman involved, that fugitive would either still be at large, or if and when they were eventually captured in that other county, the sheriff in the originating county would still have to expend time and funds to bring that person back. So as a general rule, bondsmen save local jurisdictions significant sums of money. And we do understand the sheriff's argument about cost and time, but that's not the reason we support the bill. Even though failure to appear is by far the most common reason that a bonding company would surrender an individual, the surety does have the ability, the option to surrender a defendant for any reason at all. Most often, this is because the defendant has violated some sort of non-appearance related bond condition. Like, for instance, they're supposed to check in and they've stopped checking in. They've taken some action that's indicative of an intent to flee. We've somehow learned that they've purchased airline tickets to a non-extradition country. We might want to jump the gun and not wait for them to fail to appear to get them back in. But by far the most common reason for a surrender without a warrant would be that the indemnitor on the bond, the person, the family member, the friend, the coworker, whoever's signed our paperwork guaranteeing that bond, has become uncomfortable with the defendant's situation. They think that they're using drugs again. They're not doing what they're supposed to do. They didn't get a job like they said they would. They didn't fulfill the promises, and they don't want to be responsible for that person. They can contact us and have us surrender that bond because they're concerned about that. In these instances, there is not a bench warrant for the defendant's arrest. And when there's no bench warrant and the defendant is arrested in another county and the bonding company attempts to surrender, do a formal bond surrender into some third county, this only creates problems for everybody involved. There's no arrest warrant, so the foreign, I say foreign meaning the county that the charge is not from, feels that they've got no basis to hold the defendant. The current language of the statute notwithstanding, it's not really viewed on a regular basis. It doesn't happen very often, so most counties aren't familiar with it. And then the originating county doesn't know that a bond surrender has taken place, likely. And so when County B contacts them and says they've got this guy, they're going to go, we don't have a warrant for him, let him go. So this creates a situation where confusion abounds for everybody concerned, law enforcement and bondsmen. Now, it should be noticed, this is not really a particularly common occurrence where we're surrendering people to a differing county when there's no active warrant. Rarely do bondsmen have someone sitting in the backseat of their car in handcuffs and go, you know what, I'm going to go create a problem for myself in the local jail. So while this can happen, we don't think it happens on a regular basis. KBAA views our role as ancillary to the criminal justice system, and that includes supporting law enforcement. We want to solve problems for the criminal justice system, not create problems. So in so much as this would solve a potential problem, albeit we don't think a common problem, we do support passage of House Bill 2076. And again, I'd be happy to answer any questions relating to bonding or our positions on this.
With that, Mr. Rolfe, could you mute your microphone? Is
Oh,
that...
I'm sorry. Yes, sir. Yes, ma'am.
Thank you. We're just getting an echo. I will ask then, do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, we don't have, we'll open it up then for questions from the committee to either of our conferees. I have one question. In the example that Sheriff Easter provided where the defendant was located and found in Douglas County, but the warrant or the complaint arose out of a different county. I think that would be Ford County. In the example, who then, does the bill require that the bondsman drive from Douglas County to the county where the complaint subject to the bond was filed, or who does the transporting and who's responsible for the expenses for that?
Jeff East with the Kansas Sheriff Association. This bill would require the bondsman to take that particular individual back to the county of the origination of the surety or the warrant, those type of things that was issued for it. It would not require the sheriff to pay for that transport.
Thank you. And Mr. Rolfe, your association is in favor of the bill and in favor of this procedure?
We are in favor of requiring us to conduct a formalized surrender at the appropriate county. I think the sheriff's office, if the person somehow comes into custody of the sheriff's office or comes into contact with law enforcement, they're taken into custody. I don't think this, and a bondsman happens to be involved, I don't think this gives a pass for the local sheriff to say, no, you're free to go, you go with this bondsman. Our experience is that generally local law enforcement, once they have someone, are loath to turn them over to the bonding company for transport purposes. They would just soon book them into their county jail and handle that through the normal processes when there's an active warrant. And there is another statute that requires us to notify local law enforcement when we're attempting to pick someone up. So there is a very real possibility that there's some sort of, tangential involvement of law enforcement when the bonding company is picking someone up, when where law enforcement might take that person into custody. We're supporting the notion that when we have that person into custody, we should deliver them to the appropriate county to lessen any issues for confusion.
Thank you. So it looks like the Sheriff's Association and the Bail Agents Association is in agreement and in support of the bill. And thank you for clarifying that. Committee questions, any other questions? Yes, Senator Thompson.
Just, maybe I'm missing something. How would this affect cross-state line situations? Would it, say somebody picked up in Kansas City, Missouri, was delivered to Johnson County, does that create any conflicts?
Either Sheriff Easter or Mr. Rolfe?
Yeah, this is Jeff Easter with the Kansas Sheriff's Association. If they're picked up in a different state, that causes a whole different process. And that process is extradition because they are in a different state. Now, if there is some type of agreement between the state of Missouri and the state of Kansas, because they're so close on the Kansas City area, I'm not aware of. But if we have somebody that's picked up in Kansas or picked up in Texas that has a warrant or something similar to this, that causes extradition to have to take place.
Thank you.
Thank you, Madam Chair.
Committee, yes, Senator Corson.
Thank you, Madam Chair. I had a question kind of following up on the chair's question. Do the bonds people, do they feel like if the person that they pick up is violent or abusing drugs or, you know, I guess if in the example that we've been using about Douglas County to Ford County, do the bonds folks feel like they're able to kind of safely for all parties make that transport? Are they kind of trained and equipped to do that sort of a transport I understand they're probably rarer cases, but where you may have somebody picked up who, you know, you're worried about violence or other extenuating circumstances? Thank you.
Yes, for either of our conferees.
This might be something for me. We probably, the specific question is we would always advise our members if there's some sort of problem and there's an active warrant to get that person back into custody as soon as possible. It just is a safer situation for everybody involved. I don't know if that's a direct answer to the question or not. If the person is not in a good state, we need to make sure that they're okay before we try and drive them halfway across the state.
Go ahead, Senator.
So in that case, in most instances, if that were the circumstances, the bonds person would probably take them to Douglas County jail.
If there was a warrant, we would absolutely, if there was a situation where the defendant was in distress, we would want that person back into where they could be looked at right away. We would not wait if they were in distress or some sort of problem was developing, wait to take them halfway across the state.
Senator Corson, if you don't mind, if I could expand on some of that, if you don't mind.
Sure, go ahead and introduce yourself.
Okay, this is Jeff Easter with the Kansas Sheriff's Association. Simply what this bill is doing, we have had bondsmen throughout the state that didn't have any of the situations we're talking about here, simply pick somebody up and drop them off at the local jail, and they're no longer their problem. It's the sheriff's problem. That's the only thing this is trying to address. If that individual has a warrant, say like in Douglas County, and they got a warrant in, but the bond revocation or the surety bond revocation is in Ford County, they're still going to be booked into Lawrence County to address that warrant as well. And then also, if you have somebody that is bondsman might have told us about it, but law enforcement took them into custody. No, they're ours. And the process will take place like it always has. We're simply trying to cut down on some of the bondsmen that are taking advantage of the system. It isn't a whole lot of them, but there is some that have done it on a regular basis.
Thank you. Committee, other questions? Seeing none, then, do we have any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, I have one final question for the reviser. Did this bill come to us? Who brought the bill? Was it the Kansas Sheriff's Association?
Thank you, Madam Chair.
Mr. Easter's nodding his head yes.
Yes, it's Jason Thompson with the reviser. I was just going to confirm that yes, that's my understanding. And I was going to confirm on your public website who we listed the requester as, and it is listed as Representative Patton on behalf of the Kansas Sheriff's Association, Association of Chiefs of Police, and Peace Officers Association.
Thank you. Thank you, committee, then. Thank you, Mr. Easter and Mr. Rolfe, for your testimony this morning and your time. I appreciate that. Committee, then, we will close the hearing on House Bill 2076 and open the hearing on House Bill 2093 with a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again with the Revisor's Office. House Bill 2093, as amended by House Committee, changes penalties for the crime of fleeing or attempting to elude a police officer, and also adds a provision regarding evidence in a prosecution for theft of a motor vehicle. Section 1 amends KSA 8-1568. That's the crime of fleeing or attempting to elude a police officer. Current law in subsection B of that crime penalizes a driver of a motor vehicle who willfully fails or refuses to stop, or who otherwise flees or attempts to elude a pursuing police vehicle or police bicycle when given visual or audible signal to bring the vehicle to a stop, and then commits certain acts in the process of that fleeing. The bill adds operating a stolen motor vehicle to the list of acts that if you commit that act while fleeing, you've committed this felony version of fleeing and eluding. The House Committee on Judiciary added a new subsection B3 to increase the penalty for a person who willfully drives the wrong way into an opposing lane of travel on a divided highway, willfully departs the appropriate lane of travel into an opposing lane of travel on any roadway, causing an evasive maneuver by another driver, willfully drives through any intersection causing an evasive maneuver by another driver, or causes a collision involving another driver. So if you violate subsection B1 or B2, that remains a severity level 9 person felony. But if you violate subsection B3, that is a severity level 7 person felony. So if you commit one of those acts we just talked about, involving an opposing lane of travel or an evasive maneuver, or driving through an intersection and causing an evasive maneuver, that goes from a 9 to a 7. The bill also adds a new subsection C4 to this provision that requires the court to impose a fine of not less than $500 when the driver is operating a stolen motor vehicle during the commission of the fleeing and eluding offense. The second section in the bill is KSA 21-5804. That's a statute in our criminal code related to theft that establishes certain prima facie evidence of intent to permanently deprive an owner of the possession, use, or benefit of property. The bill adds a new subsection E to provide that when you're prosecuting theft of a motor vehicle, fleeing or attempting to elude a police officer will be prima facie evidence of intent to deprive. So that just makes it easier to prove the case that if you were fleeing and eluding in a stolen vehicle, that you did intend to deprive the owner of that vehicle, and it makes it a little easier to convict you of the crime of theft. With that, I'll stand for questions.
Mr. Thompson, committee questions for the reviser. Senator Haley.
Thank you, Mr. Chair, and thank you, Mr. Thompson. I kind of think I like this bill. I guess I just have a question regarding definitions. If you could help clarify for, certainly from my understanding, the word willfully, Mr. Thompson, is that defined clearly, and would, to your interpretation, willfully operating be the same or similar standard as, say, knowingly or intentionally? And I guess my question goes that it could be possible, especially wrong way driving on a highway, that of course they're willfully driving there, but may not knowingly be going on the wrong way. So anyway, is there a definition section for willfully, and is that not a broader standard than intentionally or even knowingly?
Mr. Thompson.
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office again. Generally speaking, in the criminal code, we have the 3 intent, culpable mental states, as we call them: intentionally, knowingly, recklessly. We've kind of gotten away from willfully, but that is still frequently the term used in traffic infractions. And generally speaking, willfully is equated with knowingly. So that would be the way I understand that the prosecutors and law enforcement are interpreting that. And yes, that has a known meaning within the criminal code, within criminal offense like a traffic offense, and it's not proposed to be changed here. That's current law.
Thank you, Madam Chair. Thank you, Mr. Thompson. You know, I'm fine with the intent, certainly, of this. I am concerned where someone did not knowingly operate a vehicle in the wrong lane, but they, of course, willfully were eluding. That I'd be concerned there that they didn't know because of some demarcation on the highway that they were driving in the wrong lane. I would prefer that they knowingly or intentionally, I mean, they knew that they were driving in the wrong lane. But the other question, Madam Chair, is the bed space impact. I would imagine that the Sentencing Commission would have come back. I see in here they said they can't imagine what it would be, but they did have in the bed space impact, Madam Chair and Mr. Thompson, they did estimate, or they did have statistical information on how often these offenses occurred. I don't know if Mr. Thompson knows, or if it's for some later conferee, why we can't have a firmer grasp on what we're looking at in terms of impact. If you'd care to insert, Mr. Thompson, I know this is not directly, but you may have heard in the House committee why they don't have a more exact number, Madam Chair.
Mr. Thompson, if you can.
Thank you, Madam Chair. Jason Thompson again. I don't have anything specific other than what it says in the findings of the Commission's bed space impact. Just that they do not have data in their sentencing database that tracks whether the convictions were committed in a stolen vehicle. So they're not sure how that would impact the 7 convictions for severity level 10 person felonies that they had in the database. And the 411 convictions they had for severity level 9 in the database. And they also say they're not able to track the data on theft convictions where the specific result was driving a stolen vehicle. So it's basically just a lack of the ability to get that fine-tuned in the data, is my understanding.
Thank you. Other questions from the committee for the reviser? Seeing none, then we will, I have just a quick question. The bill was introduced by, was it the Sheriff's Association again? Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. Let me confirm what the public record says, just so I don't speak out of turn.
Right, I can ask, I think the conferees can address that.
Well, and yes, I can just tell you the website does say Representative Patton on behalf of the Kansas Sheriff's Association. Just took a second for it to load. Thank you.
Thank you. Then committee, we will invite our first proponent conferee, Mr. Ed Klump of the Kansas Association of Police Chiefs, Kansas Sheriff's Association, and Kansas Peace Officers Association. Mr. Klump, please introduce yourself and welcome back to committee.
Thank you, Madam Chair, committee members. Ed Klump. I am here representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. I think the records got kind of reversed on these two bills today. The Sheriff's Association was the single association that had the bond bill, and this bill was actually requested on behalf of all 3 of the associations. This bill, we started working on this bill actually in 2018. We first presented it to the legislature in 2019. And this bill is about auto thefts. It is not about attempt to elude. But we have a significant number of attempt to eludes involving stolen cars, and that's how that became part of this bill. This bill passed out favorably in 2019 out of this committee, went to the floor, and did not get above the line that year. And I cannot tell you why. When you passed the bill out in 2019, it had a provision in it that would make a stolen vehicle under the value of $1,500 also a felony. The House took that out. It is not in this bill as you see it today. The There are two additional amendments in this bill that I want you to be aware of, and I'll cover those more thoroughly, that were not in the bill in 2019. And that is some enhancements to the attempt to lewd statute and a clarification of how multiple prior convictions for attempt to elude are counted in certain sentencing decisions. And I'll talk about those specifically. If you look on page 1 of our testimony, I'll show you real quickly in pictures why this bill is important, why we need this bill. Look at the top chart on the Kansas reported auto thefts. Since 2009, Kansas has been on an upward trend of auto thefts, and it continues. Look at the U.S. reported auto thefts. We have, well, there was a spike in the national data starting about 2016. It never got to the level of 2009. So the downward trend nationally is downward. And you can see since 2017, it's significantly going down where we're significantly going up. That's what we're trying to address in this bill. So the 2020 increase, we anticipate that data is not out yet, but we anticipate that it's going to be an increase of about 10.3%. And what we base that on is we looked at the number of NCIC entries for stolen cars compared those 2 years, and there was 10.3 more data entries for stolen cars in 2020. So we anticipate that number is going to go up again in 2020. In 2019, the Topeka Metropolitan Statistical Area was the 9th highest per capita rate of stolen cars in the country. I will tell you in 2018, and this was in our testimony last year to the House, Wichita was the 7th highest in the country. And so Kansas is clearly leading the pack on our stolen car rate, which is not a good thing. So there is some data out there about the average cost of a stolen car to the victims. And if you take that times our estimated number in 2020, Kansas sees a loss of about $79 million a year in stolen autos. And that's a minimum. It's probably higher than that. There was a January 15th news article of this year in the Kansas City paper. Overland Park was reporting in 2020 they had a 42% increase in auto thefts. Lenexa, 87% increase. Shawnee, a 39% increase. Wichita actually showed a little bit of an increase in 2020. But when they looked at their 2021 year-to-date compared to 2020 year-to-date, their auto thefts were up over 50% over last year, the same time period. So this just keeps climbing, and we need to do something to resolve this auto theft issue. Public safety does not stop with the theft of the vehicle itself or the results of the resulting attempt to elude cases. Many of these vehicles are used in other crimes as disposable getaway vehicles, methods to haul away stolen property, black market drug sales, and other illegal activity. One large Kansas City agency was able to identify in 2018 that 30% of their stolen cars were used in other crimes. So somewhere north of 30% are used in other crimes. One of the problems we have is many of our auto thefts, even when the value is higher than $1,500, gets charged as a misdemeanor because it is difficult to prove the person who we catch in the vehicle knew that the auto was stolen. So one of the things that we're asking for in this is a amendment to the statute on the presumptive as the revisor described. So here's what this bill does, just real quickly, and why we have that in the bill. On page 1, line 35, you'll see in the attempt to elude statute, there is a series of conditions where an attempt to elude becomes a felony, and we want to add to that that they are fleeing in a stolen motor vehicle. On page 2, on lines 23 and 25, it imposes that $500 fine, minimum fine, that the revisor spoke about. And here's why we want to do that. In reality, today, there is usually no penalty for attempting to elude because it gets wrapped up in the sentence for the other crime that they're fleeing for. And so the end result is they're getting penalized for the base crime that they committed anyway. They're getting no penalty for the attempt to elude. And so in the mind of the offender, why not try it? It's not going to be any worse for me if I just pull over and get caught for what I'm trying to run for. And so we felt like there should be some kind of skin in the game, some kind of penalty for certain added to the penalty when there's attempt to elude. In Section 2, that's the prima facie evidence of intent to permanently deprive in a theft case. And that's where we want to add the provision that if they attempt to elude in a stolen car, that's prima facie evidence they knew the car was stolen. At our request, the House Judiciary Committee also added the following amendments to the attempt to elude statute. First one actually came to us from the KHP, and it would address a problem we have, and we see this more regularly in the stolen car attempt to eludes, where they will actually take and intentionally go across a divided highway into the oncoming traffic, and that's an effort to get us to stop the pursuit and let them go. And obviously that's an extremely dangerous situation when these cars are not only on the wrong side of the highway, but they're driving at a very high rate of speed on the wrong side of the highway. It also covers attempt to elude causing a collision with another vehicle, and anytime they go on the opposite side, even on a two-lane road where they cause a vehicle to take an evasive action to avoid a collision. A question was raised earlier about the bed space issue, and I'll say one of the things that probably keeps that low is even in this provision, when you go to a severity level 7 felony, severity level 7 felonies are primarily presumptive probation unless the person has an extensive record already. And so that's another thing that makes it difficult to nail down exactly what that bed space would be. And finally, another amendment you'll find on page 2, lines 9 through 18, came to us from a prosecutor, and it is an effort to clarify how prior convictions are counted between the two subsections A and B of the attempt to elude statute. And so, Madam Chairman, that's my testimony. That's our testimony. We would appreciate consideration of this bill. This auto theft thing, it just keeps getting worse. Our attempt to eludes keep going up involving these vehicles, and it's time we strengthen these laws so we can start bringing these numbers down. Thank you, and I'll stand for questions.
Thank you. We next have our next proponent conferee, Mr. Greg Smith, Johnson County Sheriff. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I am Greg Smith. I'm a Special Deputy for Government Affairs for the Johnson County Sheriff's Office. And there's basically three areas that I'd like to discuss very briefly that are all in my testimony. First of all, talking about the car theft problem in Kansas. In Johnson County, we are seeing that problem. Mr. Klump referenced that in the article and the report that was done early this year in January. 2015 and 2016 in Johnson County, Kansas, the Sheriff's Department's jurisdiction, primary jurisdiction, which is the unincorporated parts of Johnson County and the cities of DeSoto and Edgerton. It's about 40% of the total geography of the county that we have sole jurisdiction over in responding to these types of cases. 2015, 2016, we had a stolen car each year. In 2018, it jumped to 13 stolen cars. 2019, we saw a 200% jump with 39 cars reported. And last year, we had a 10% increase of 43 vehicles. And as Mr. Klump said, there were huge jumps in the city jurisdictions located within Johnson County, and Overland Park had a record-setting year. So this is definitely a problem that we need to deal with. The International Association of Chiefs Police has been doing research on the problem of auto theft for years, and their research has found that auto theft, to coin a phrase, is a gateway crime. 97% of car thieves face some kind of other serious charge. And let's be frank, if you're going to commit some type of crime, it helps to have a car to be able to get away or to get to wherever you're doing your crime, whether that be a shooting, a robbery, drug deal, whatever it is. Lastly, we referenced this, I think last year, in last year's bill, but it's not in this year's bill. We would like to see an amendment added to this bill that has to do with the value amount of property theft. The language we have in our testimony is theft of property that is a motor vehicle is defined in KSA 8-126 and amendments thereto of the value of less than 1,500 is a severity level 10 non-person felony. We feel that this is a victim-centered amendment to the bill. That's kind of offering some level of justice to those Kansans whose vehicles aren't worth $1,500. But data shows that of those vehicles that are stolen, 31% of them fall into this category. And those vehicles are more likely to be owned by lower income families, maybe a single parent family, and are the only means of transportation this family has. And so it's less likely that they're going to recover from an insurance policy because it's probably not covered for theft. So these families are hit really hard by the loss of a vehicle that they can't replace. And quite frankly, it's insult to injury when they find out that their stolen car is only a misdemeanor rather than a felony. So we feel that this would offer some level of justice for Kansans that fall into that category. And with that, Madam Chair, I'd be happy to stand for questions.
Thank you. Next, we'll hear from proponent conferee Herman T. Jones of the Kansas Highway Patrol. Please introduce yourself and welcome to committee.
Good morning, Madam Chair. My name is Lieutenant Roy Wise. I'm with the Kansas Highway Patrol, and I'll be speaking on behalf of our superintendent for the patrol, Colonel Herman Jones. Additionally, he provided written testimony for the committee to review. We are here today to support House Bill 2093. Motor vehicle theft in Kansas has unfortunately become an increasingly common crime. 10 years ago, our agency recovered 129 stolen motor vehicles. In 2019, we recovered 471 stolen vehicles, which is an increase of 265% over that roughly 10-year period. According to the Insurance Information Institute, the average dollar loss per theft of a motor vehicle was just under $9,000. So using this figure, in 2019, the patrol alone recovered over $4 million in stolen motor vehicles. Motor vehicle theft is devastating to Kansas citizens and families, as vehicles, previously pointed out, are oftentimes families' first or second greatest financial asset. Regarding pursuits, motor vehicle theft also commonly leads to them. In 2010, our agency reported 11 instances where possession of a stolen vehicle was identified as the primary reason that a pursuit was initiated. 10 years later, approximately 70 of our 438 pursuits were primarily initiated because the driver was in possession of a stolen motor vehicle. Significantly, this only represents pursuits in which the suspect was apprehended. It does not include those pursuits that were terminated by the officer or pursuits that were the result of other serious crimes. Pursuits represent one of the most hazardous activities that our agency must engage in to protect the motoring public. And in recent years, our agency has observed dangerous maneuvers being carried out by fleeing suspects that pose serious issues of safety. The most perilous of these actions occur when suspects intentionally drive left of center and into oncoming traffic, or when suspects enter an intersection in such a way that other drivers are forced to perform evasive maneuvers in order to avoid a collision. Unfortunately, some criminals have come to believe that driving into oncoming traffic or driving recklessly through intersections will increase the likelihood that police will end the pursuit. And so criminals are now intentionally driving dangerously in order to evade capture. And of course, all too often, these acts result in crashes that lead to serious injuries or deaths. It is our agency's goal to vigorously pursue, apprehend, and prosecute those who utilize Kansas highways for criminal activity. House Bill 2093 would assist the patrol in carrying out our mission and goals through deterrence and penalization of those who choose to victimize and jeopardize our citizens by committing these crimes. Thank you, Chairman, and thank you for the opportunity to speak today. I'll be happy to answer any questions when the time is appropriate.
Thank you. We will next hear from Todd Thompson, Leavenworth County Attorney on WebEx. Please introduce yourself and welcome back to committee. We don't have Mr. Thompson on the WebEx call yet, so we'll check back before we close the hearing. But I will then ask for, do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then, committee, we will open it up for questions of our proponent conferees. Yes, Senator Thompson.
Thank you, Madam Chair. I fully support and understand the intent and idea behind this bill. I do have one question. How do, and this is just a little devil's advocate question, really. How do we handle people who say have a medical emergency, they're racing to the hospital, suddenly they're pursued by police and they panic, they want to try to get, say, a spouse having a heart attack. I mean, there's latitude in there for judgment of the officer who stops them. Is that correct? Or how do you handle that? I'd hate to see somebody trying to get somebody to the hospital and didn't have time to wait for an ambulance and get charged with a felony. I'm just curious how you would see that or handle that using this bill.
Yes, did any of our conferees want to reply? We have Mr. Klump approaching the podium, and so we'll let him reply first, and others can add. Thank you, Mr. Klump. Please introduce yourself again.
Ed Klump, Kansas Association, Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. Yes, we have discretion on calls like that. Frankly, I don't think any prosecutor would ever charge a case like that as attempting to elude. The key component of attempting to elude is to elude and to get away from us. So we frequently have cases, for example, where a person chooses to try to get home to where they have family to come out of the house and confront us when they get stopped. They don't speed. They don't do any of those things trying to elude us. They just fail to yield, and that's a separate violation if we chose to charge it at all. So yes, we have latitude in that.
Okay. Thank you. Thank you, Madam Chair.
Did any other conferee wish to respond, or do we have that covered?
Madam Chair, this is Greg Smith with the Johnson County Sheriff's Office.
Go ahead, Mr. Smith. Thank you.
Thank you. I think it's also important to note, Senator Thompson, that most people that are going to the hospital or some instance like that usually aren't doing it in a stolen car. And these enhancements are for somebody that is in a stolen car rather than somebody that's trying to get to medical assistance. And as Mr. Klump said, that's probably not something we're going to charge somebody for after that's been verified.
Thank you.
They might be shot and trying to get to the hospital. I could see that happening, but yeah, thank you. Thank you, Madam Chair.
Senator Wilborn.
Thank you, Madam Chair. I'll ask the question of Mr. Klump, if you would. I assume that the person felony level 7 and the personal felony level 9 was in consultation with the Sentencing Commission as it relates to proportionality and the right level for what the crime is.
Mr. Klump.
Ed Klump, Kansas Sheriff's Association, Kansas Association, Chiefs of Police, Kansas Peace Officers Association. I don't know if we had a particular discussion relating to proportionality. Proportionality is something I'm very familiar with. When I served on the Recodification Commission, I worked on our proportionality subcommittee. So I do think this is proportionate because of the increased risk that is involved in that additional act taking place during the attempt to elude.
Thank you.
Thank you. Senator Pyle.
Thank you, Madam Chair. My question is for Ed. I'm looking at the charts that you passed out, and I'm curious, you say that we've increased. Are those per capita increases, or are they actual number increases where we actually had the most cars stolen in Kansas, or are they based on per capita?
Thank you, Senator Powell, for that question. Ed Klump, Kansas Association, Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. The charts are based on actual number of auto thefts. However, the data, for example, in Topeka and Wichita for the metropolitan statistical area was a per capita rate.
Okay.
And I have that data on the per capita rate. If you'd like it, I can provide that.
Just to follow up, is there anything, okay, so we're seeing this increase. Is there anything that's in those increases, like such as drugs, any sex trafficking, anything that's tied to those that could help to relate to that? I mean, or is it just they're still in the cars to be mobile? Are they still in the cars to part them out? What is there? Can you comment, please?
Well, again, Ed Klump, Kansas Sheriff's Association, Kansas Peace Officers Association, Kansas Association of Chiefs of Police. I'm getting to say that pretty fast. I wish I could give you that answer, but we just don't have the data to say with certainty. Anecdotally, we know that stolen cars are used in a large number of robbery cases, because if somebody sees them leaving the scene of the robbery, then all we've got is a stolen car description. They take that car then usually a mile or 2 miles away, dump it where they have another car parked, and they transfer to their own car. We know they've been used in drive-by shootings. We find drug trafficking occurring on a regular basis. So we know that those are kind of the key ones. We know that many of these cars are never recovered, which means they probably got chopped up and sold as parts. And so, you know, all of those things are in play. I just can't tell you with what proportionality.
Senator Haley.
Thank you, Madam Chair, and if you will, Chief, Mr. Klump, I get back to a couple quick points. First, I want to get back to the concern that I have for the language. In fact, during your testimony, you kind of interspersed the word intentionally with the word willfully. And in reading section 3, what is that, B3, I guess, the top of page 2, my only concern is willfully drives the wrong way into an imposing lane of traffic on a divided highway, and willfully departs the appropriate lane of travel into an opposing lane of travel or any road causing an evasive maneuver, willfully drives through any intersection causing. I understand all the other willfuls except the very first one, and I am concerned if somebody were everyone who's driving in a lane is driving willfully by definition, but intentionally or knowingly. I just, we've been around this a long time, sir, you and I, and we know the different standards. I remember the one with guns, brandishing, all that other, but this is a concern of mine because someone can be now charged with a felony where they did not knowingly drive on a divided highway or even on a main highway. And so that's the first of two quick points I'd like to ask you to.
Again, Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. And as the revisor explained, willful is the terminology that is used through Chapter 8, the traffic codes. And I would suspect that's why that term is used here. Had it been in a Chapter 21, they would have used one of the other three terms, I'm sure. From our perspective, I don't think it matters which, if you wanted to change that to intentionally, I don't see a problem with that. It may be a little higher level of proof. And Madam Chair, if I might suggest we ask a prosecutor, Todd Thompson, if he's still on the WebEx, for his opinion of that.
Do we have Mr. Todd Thompson, Leavenworth County Attorney, on WebEx yet? No, we don't.
Okay. I guess you're stuck with my answer then.
That'll be fine. Yes, Senator Haley.
Thank you, Madam Chair, and thank you, Mr. Klum. Well, I certainly don't want to see this potentially amended because it doesn't need to go to conference, but I certainly am concerned, remain concerned about that definition. And my other quick point is, I don't subscribe, but I'm wondering how you might, during your testimony, to the enhancement of a penalty, especially for first offenders, leading to the decrease for auto thefts. I mean, the correlation, which is philosophical, is that just because there's a higher penalty, especially for first-time offenders of this, that it's going to have the residual effect of decreasing what the underlying crimes are. That is, I know, I just point that out. I do appreciate you've shown us that Kansas is going up in auto thefts while the nation's going down. I don't know if the enactment of this bill personally would decrease auto thefts in and of itself, but just share that with you. And finally, sir, and this was probably what Mr. Smith was talking to, perhaps you would share. Mr. Smith, Madam Chair, and for the committee, was former vice chair of this Senate Judiciary Committee, and he and I did not often agree on something that actually Senator Thompson's predecessor, who also was on this committee, Senator Pilcher Cook, did. That's the threshold of loss, $1,500. Senator Pilcher Cook and I certainly felt that one who is at that threshold, who is deprived, as Mr. Smith testified, is equally bereft, if not more so. Why, Mr. Klump, or maybe Mr. Smith, would we not include that, other than the fact that it's going to skyrocket? Because the loophole is going to be there when it gets out among these criminals that, you know, carjack or steal an undervalued car, a hoopty, as they used to call them, and you're not going to have the higher penalty. Why would that not be included, sir?
Madam Chair, if I may answer, Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officer Association. That was in our original bill. We still support that concept. The House had difficulty with that part of the bill. They stripped it out last year. We tried to put it back in this year. They again left it out. And so we chose not to come over here trying to add it back in. You heard Mr. Smith suggest that it should be. We still support that. I will tell you, one of the things that was in the discussion on the House side was a concern with low value, say less than $500 value vehicles. For example, an inoperative vehicle that's sitting out by a garage was an example that was cited. It's probably worth $200 and it's junk, it doesn't run. And would that be covered if we went that route? So if you put that back in, I would suggest maybe something like an automobile or a motor vehicle of a value of more than $500, less than $1,500, and we alleviate those kind of actual low-cost vehicles. Motorcycles, some motorcycles, you know, would be less than that. But you know, we'd love to see it go back in. Ultimately, it's going to have to be worked out with the House whether that stays in it or not.
Madam Chair, and thank you, Mr. Klump, but as far as I'm concerned, whatever the value is, and you can get different values, whether you're looking at Carfax or, you know, one of these various websites, if it's drivable and operable, and it can drive the wrong way, or if it can flee and elude, I don't care what its value is, especially if it's the main transportation or was the main transportation of someone from which it was stolen. But thank you, sir, and thank you, Madam Chair, for the indulgence.
Thank you. Committee, other questions? Seeing and hearing none then. Thank you to our proponent conferees, Mr. Klump, Mr. Smith, and the name of the Kansas Highway Patrol officer I didn't quite catch. Lieutenant Wise, thank you very much. It's an area of concern that in my Senate district in Johnson County, I hear more and more of auto theft. In fact, sometimes straight out of the driveways in the neighborhood. So I'm glad that there's a bill to address this. You had said, Mr. Klump did, that the auto theft rate is increasing, kind of an alarming rate in Kansas. So thank you for bringing the bill to us. We do have Mr. Todd Thompson is on WebEx now. Is that right? No. So we will then ask for, are there any other neutral conferees or any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. Any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then, we're going to have to close the hearing on House Bill 2093. Mr. Thompson was another proponent conferee, and we've tried a couple times throughout the committee meeting today to hear from him, but just wasn't able to due to the fact that he wasn't on WebEx. So with that then, committee, we will close the hearing on House Bill 2093 and open it up. We have a few minutes left for discussion on Senate Bill 9. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office. Very briefly, Senate Bill 9 requires newly certified law enforcement officers to attend diversity meetings organized by the Kansas Commission on Peace Officers Standards and Training. That's what most of you know as CPOST. The bill enacts a new section of law that would be part of and supplemental to the Kansas Law Enforcement Training Act. Every officer, every police officer or law enforcement officer who is issued a certification by CPOST on or after January 1st of 2022 would be required to attend one diversity meeting within 6 months after that certification is issued. And the commission would be required to schedule not fewer than 2 diversity meetings each year. Those meetings would be open to any police officer or law enforcement officer who was issued a certification during the immediately preceding 6 months. And for each of those meetings, the commission would be required to invite prominent members of minority communities, and then would also be allowed to invite other individuals, including members of the general public. The Kansas Human Rights Commission would be required to provide the CPOST Commission a list of individuals who are prominent members of minority communities across the state, and they would use that list to invite the appropriate people to these meetings. And finally, on or before January 1st of 2022, CPOST would be required to adopt rules and regulations to implement this new section. And I will stand for questions when appropriate.
Thank you. Committee questions for the reviser? Seeing and hearing none, then Senator Wilborn.
Thank you, Madam Chair. Just for my personal interest, who requested the introduction of this bill?
Mr. Thompson?
Thank you, Madam Chair. Senate Bill 9 is sponsored by Senator Fausto.
Thank you.
Thank you. Committee, do we have any folks who are in the committee meeting room who would like to add to discussion on Senate Bill 9 or on WebEx? Mr. Yes,
Chairwoman
go ahead.
Warren, this is Jeff Easter with the Kansas Sheriff's Association. I don't know if you're asking if we had any discussion points that you would like to hear or not, but if you do, I would like to provide some of those points.
Sure, go ahead.
Some of the concerns with KSA, KACP, and the Chiefs Association is that this particular bill, we would want to see what's the ultimate outcome of this, and is there a curriculum or an agenda? We need to have these meetings. A lot of agencies are already having these meetings and have been for quite some time. And it's mainly to build unity within the communities, trust, and those type of things with law enforcement. It's been sometimes our experience, and in particularly mine when I was with Wichita Police Department, this avenue was tried, and it really was not a well received. When you had members of the community just came in and had nothing good to say to our police officers that were making go to this, that and a lot of racist type connotations, and they were asked to leave. And so we understand there's issues throughout the nation, and we understand that those dialogues have got to take place. And I think that law enforcement is starting to listen a lot more than maybe we have in the past, but we just have concerns with some of the bill makeup. As the commission referenced in this, is it the Commission of Peace Officer Standards or Human Rights Commission that's going to be delivering these meetings? The other thing is at least 2, within 6 months. CPOST and KLATC hasn't even been able to look at any of this to say how this would even take place. Many of the small agencies, if they're, their new officers or deputies are required to go, where would this be at? Is it going to be a regional type thing? Is it going to be, we're going to have one in Kansas City and one in Wichita, and they're required to come? I think that brings up a second issue. Issues in Elkhart, Kansas, involving police relationships with minority communities is much different than it is in Wichita, Kansas. And so are these meetings going to be broke out in a region so that issues that are taking place in Western Kansas, which are different than taking place in Wyandotte County or Sedgwick County or, Concordia, Kansas, those are issues that I think needs to be resolved before we pass this out. I think I will tell you one of the bigger concerns that I've had reading this. What is the definition of a prominent member of the minority community compared to just a minority community member? What is that definition and what does that mean? Because I know a lot of community members that want to represent their community and do it by being involved in different dialogues and conversations with law enforcement. Are they prominent? I don't know. They're not elected. They're not on any type of board, but they give a lot of good feedback from the community, which the community wanted them to talk to us about. So I think there's issues with this. I don't think it's a deal that, that no, we could never have this or those type of things, but there needs to be a lot more in this bill to explain exactly what it is that we're looking for. How does this build a dialogue of unity and those type of things, and who actually represents the community on these boards? And thank you very much for letting me speak.
Yes, were there others in the committee meeting room who wanted to add to the discussion? I see Mr. Klump approaching the podium. If you want to introduce yourself, and welcome back to committee.
Thank you, Madam Chair. Ed Klump, Kansas Sheriff's Association, Kansas Association, Chiefs of Police, Kansas Peace Officers Association. I just want to add a couple things to what Sheriff Easter said. I noticed in the bill that they are proposing that this be a part of the Kansas Police Officers Training Act or Peace Officers Law Enforcement Training Act, which I think means the commission refers to that commission, but it isn't plain since we also have reference in the statute to another commission. And so we'd like that, that is a concern. I think another big concern that we have that Sheriff Easter didn't mention is this clearly would be under the purview of KLETC and CPOST, and yet we haven't had the opportunity to hear from them on any concerns they may have or how this would work, nor have we had those conversations with them. And I think that's a concern that they haven't had input into this. Thank you.
Thank you. Others in the committee meeting room or on WebEx who might want to add to our discussion here today? Yes, that would be Senator Haley in the committee meeting room. Yes, Senator.
I didn't know if you were looking for conferees or members of the committee. Thank you, Madam Chair.
Or committee members.
We're right up against the hour, the noon hour. I am not familiar with this bill. I certainly appreciate it being brought and appreciate, Madam Chair, you're having a discussion on it and the input from both Sheriff Easter and Chief Klump. It is the beginning of a dialogue that should be had. I do appreciate the observation brought by Sheriff Easter. I have not visited with Senator Fascadeau about this. The broader picture beyond this, Madam Chair and members and those who are listening in, and we know it, we do need to better evaluate policing and law enforcement practices and tactics, whether it's relationships in any specific communities or how we implement them. Not to go afield of Senate Bill 9, my personal preference would see areas of policing reevaluated, included in that teaching or in these diversity meetings or in the certification of new police officers, including, but not limited to, certainly chokeholds, and whether or not they should continue to be employed, or how we implement no-knock warrants in our state. That's not in Senate Bill 9. I do appreciate the fact that it's scratching the surface of better clarity or understanding and interactivity of our law enforcement with various communities. And I appreciate again that the chair has at least had a discussion on it. There are other measures before this session's out that in response to growing national concerns regarding law enforcement, criminal justice reform, that I would hope we would undertake as well, that Kansas would not remain in the abyss of non-responsivity to. Thank you, Madam Chair.
Thank you. Other comments or discussion from committee members? I just want to add that the Senate Judiciary Committee, I think, as we all know, has been very busy taking up policy matters from day one, whether it would be Value Them Both or the Kansas Emergency Management Act, or we have had an unprecedented number, actually, of confirmation hearings for appointees to the Kansas Court of Appeals. I think we have had 4 in our time together this session, and we've looked at a lot of policy pieces. I think our work on statutory speedy trial took, if I went back and counted, I think 6 separate hearings on statutory speedy trial that I think we did great work in. We also heard from the judicial branch and the executive branch on those. So it's an issue that the issue addressed in Senate Bill 9 is, like the good senator from Wyandotte had mentioned, a start, and it hasn't been an ability to get the bills worked or heard because of our busy schedule. And now, due to the legislative calendar, it's some of those are past the time when we can open them up for hearing, but we will certainly continue to look into those matters. It's not an issue that has been directly brought to committee or discussed by a representative of the governor's office. So we will see where we are. Is there other comments from the committee? Yes, Senator Baumgardner.
Thank you, Madam Chair. I appreciate you bringing this for our committee. I think that there's a difference between law enforcement practices and law enforcement interaction. This bill has to do with law enforcement interaction. I'm always concerned when we're mandating meeting times, but we're not giving guidelines as to what should occur in those meetings. But when we are talking about minority communities, I think it's important for us to look beyond skin color and make sure that we are talking about other minority communities, such as the mental health community, those with bipolar disease or schizophrenia, suicidal crises. We have the folks, the nonverbal autism spectrum folks. We've got gangs in our community. So those are all paramount that our law enforcement has that appropriate interaction with those groups to mandate what that would be, or to make sure that a commission is going to come up with the list. I think, again, we need to make sure one size does not fit all in our counties and in our communities. But I do think we need to make a delineation between what is law enforcement interaction and what are law enforcement practices. Should we address both? Absolutely. I don't think we are ready for this. I think there was an intention to get something moving, but we're not ready at all. Thank you, Madam Chair.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I would like to add something briefly to what the good senator from Miami just said. And about a month ago, I attended a funeral of Senator Bud Estes. And the community leader spoke up about how Senator Estes reached out to the Somalian community. The point that the good sheriff made was that each community has a different set of ethnic interests, and it's much broader than what we sometimes think. And there's so many other interested parties that we have to take a broader look at this. Thank you.
Thank you. Yes, I agree with all the comments brought by the committee members today that this is an issue that we need to have additional guidelines in place moving forward and to look at law enforcement interaction and law enforcement practices. So appreciate the start of the conversation, the start of the discussion, and everyone's interest in that conversation. And with that then, committee, we will close our discussion on Senate Bill 9 and thank everyone for their attention today. And I apologize for running a few minutes late, but we are adjourned. Thank you.